news from Switzerland. A Swiss court has agreed to hear a climate-related legal complaint against cement giant Holcim in what campaigners say is a landmark case for Switzerland. The case was filed by 4 residents of Indonesia's low-lying Pari Island, who argue rising sea levels linked to global warming have caused repeated flooding and that Holcim is not doing enough to cut emissions. The court's decision marks the first time climate litigation against a major corporation has been admitted in Switzerland. Holcim says it will appeal, stressing its commitment to reach net zero by 2015 and noting it has already cut direct emissions by more than half since 2015. Now, joining me in this discussion is Sankalp Suman. He is the Chief Climate Strategist at Upanishad Climate Consulting, and he joins us from Tokyo in Japan.
Hi.
Hi, Sankalp. Thank you for joining me in this discussion. And now, firstly, how do you see the developments that are coming up, particularly, how do you think it influences Swiss climate lawsuits?
Right. So thank you for having me. And I think this is a particularly very landmark moment for climate justice because it makes corporate harm as legally arguable in courts. Now, from here on, whatever would happen, there are so many other Swiss companies that can be taken to court because of their climate footprint. Now, their cases would not be dismissed as easily because a precedent has been set. And it's also curious because, we had the International Court of Justice coming out with its own judgment last year where its legal advisory opinion that states can be held responsible for their climate footprint and even reparations can be paid. Now, this means it's not just states, it's the corporations, functioning within the states that can also be held responsible. This is sort of in line with what is happening in other parts of Europe. For example, there's a case against Shell going on in Netherlands. There's a case against RWE going on in Germany. In Netherlands, I think the district court had initially asked Shell to cut down their emissions by 45%, which was upturned later on. But so this means that there's a larger movement at place, and this has made its headway into Switzerland. And it also means that the recognition of transboundary harm is being done internationally, that it does not mean that your carbon footprint is only impacting in Switzerland, even if it's going as far away as Indonesia. There are people who can claim reparations because of it, and the courts might be willing to listen to it.
And particularly over the question of CSR and corporate responsibility, what precedent is this admission of the lawsuit going to set?
So yes, this means that, beyond emissions, companies will also be held accountable for what their carbon footprint is, what their claims are for reduction, what is their ESG strategies, whether they meet them or not. Over the last couple of years, we've seen a host of companies get out of the science-based target initiatives, which they had initially pledged to join, where they were supposed to meet the net zero by 2050 target. They have come out. This includes large giants like Moody's and Barclays also. So this means that, if such companies go back on their word, they can be held responsible to the court. And Switzerland is home to many MNCs, including Nestle, Vitol. Many oil and gas trading companies are based out of Switzerland. So all of these companies are now under the ambit of being able to face consequences on their previous claims. This means that they have to increase their CSR spending on environment. This also means that they have to take their climate claims more seriously than they are doing. It cannot be that they make one claim today and then they come back out of it the next day.
All right. Well, thanks, Sankalp, for joining me in this discussion. Unfortunately, that's all the time that I have. Viewers, thank you for staying tuned to NewsX World. We keep updating you with all the latest news from around the world right here. Stay tuned.